If you have a credit card or a party to pretty much any sort of contract, you've probably given up your right to use the courts to resolve problems you might encounter. We'll talk about arbitration right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
The use of arbitration to resolve disputes is quick, certain, and potentially very expensive. My guest is attorney and former West Virginia Supreme Court Chief Justice Richard Neely. Richard, thank you for joining us today.
It's always fun to come to Morgantown. I watch you all the time.
Well, thank you.
So I've never been here before, so it's nice to finally be on this side of the camera.
Well, we want to talk about arbitration. Can you explain for the audience what arbitration is, what the purposes of it are?
Originally, arbitration was designed for what I call commercial parties. That's not consumers, not laborers, not workers, not housewives. It's for banks, it's for contractors, it's for architects, it's for factories, where the delay of the court system really might destroy a whole lot of really important interests. Let me give you an example. About 30 years ago, there was a construction project in Fairmont to build a shopping center up on a hillside not too far from the Fairmont Field Club. There were three parties involved. There was a bank, there was a developer, and there was a contractor. They did core drillings to see if there was rock, but they'd somehow missed the real rock that was there. And when they went in to begin to build, they suddenly hit a huge layer of rock, I mean 40 feet. The question then was, who's going to pay to remove the rock? The contractor said, that's not my problem because I didn't contract to do a rock removal. The bank said, we're not lending any more money. And the developer said, I don't have any money to pay to remove the rock. Well, the thing went to court, and that thing sat up on a hillside for at least 5 years before anybody came up with any kind of a definite answer as to what was to be done. That's the kind of commercial situation that prompted the development of the law of arbitration. It was designed for those kinds of commercial parties. It has now been perverted and used as a weapon by big enterprises, AT&T, you know, your cell phone network, your cable television provider, your credit card company, as a device to defeat people's legal rights.
I know most arbitration agreements or clauses that I see include language essentially to say you have to participate in arbitration. The arbitration is going to be at the headquarters of the company that you're dealing with, and it seems like nobody's headquartered in West Virginia anymore. If you've got a credit card, you're talking about going to South Dakota or Delaware or something like that. Or if you're dealing with AT&T or any of those bigger companies, they're always somewhere else. And that each party has to bear the cost of their own representation in the arbitration, and the loser is going to have to pay all the costs. That can be blindingly expensive.
It is. It is blindingly expensive. It is a combination of something called a forum selection clause, which means we're going to try this in North Dakota, and we're going to apply the law of North Dakota, and an arbitration clause. The arbitration clause, no one understands. Now, if you're in Mannington, West Virginia, or in Petersburg, right, or in Man in Logan County, within 25 miles of you is some lawyer with a storefront office who actually knows how to use the courts. Each of these arbitration clauses is different, and no one has access to them. You have to first figure out, what does the arbitration clause provide? Lawyers know how to use the courts. The courts in West Virginia are the same everywhere. In fact, the courts in America are largely the same everywhere. Arbitration is different everywhere. So if you're a consumer and you have a problem with AT&T, you have to first figure out how you start an arbitration, and then you have to begin the arbitration process. Now, I have actually had kids who were friends of my children. I say kids, they were college students, or they're medical students, who've had big fights with AT&T. I go into the Secretary of State's website. I look up who is the general counsel of AT&T. I send him a letter on my letterhead which says, "We hereby invoke the arbitration clause. Please respond within 30 days and send us a copy of the rules, or we will deem the arbitration clause to have been waived." Now, that's very effective. You actually get a reaction from the company when you do that. But you have to be a $500 an hour lawyer to know how to do it. I mean, that's the whole problem. That to find somebody who is able to get around the arbitration provision, you have to spend more money than you would spend just bringing a lawsuit.
How long have we been doing arbitration? Where does it come from?
Where it began was with something known as the Federal Arbitration Act that was passed in the late 20s, early 30s. And it was designed to make arbitration available to commercial parties. Now, I'm not the only one who says this. Clarence Thomas on the United States Supreme Court says the same thing. The purpose of the Federal Arbitration Act was simply to make it possible for people like my bank, developer, and contractor to agree to have some kind of a quick method of resolving a dispute. And some of the good things about arbitration are that arbitration doesn't necessarily follow strict legal rules. Arbitrators are often allowed to apply principles of fairness, what's called equity principles, in the arbitration. So you also don't have the application of strict rules of evidence. So in a commercial setting, the kind of flexibility that arbitration allows is very helpful to commercial parties. What happened was that the courts are very crowded. The court system nationwide is not terribly well funded. West Virginia has the best funded court system in the United States. I mean, the West Virginia Supreme Court issues a warrant to the West Virginia legislature, and the legislature gives the Supreme Court as much money as it needs to run the court system. So we actually have a well-funded, well-working court system in comparison to most other places. But in most places in America, the court system is very crowded. And judges have tried to figure out a way to get civil cases out of the court system. The federal courts, led by a Republican majority on the Supreme Court of the United States, are extremely protective of business. And so they have expanded the reach of the Federal Arbitration Act to allow AT&T to put a clause into your cell phone agreement that provides that arbitration shall be conducted in New York City under the rules of the American Arbitration Association, and that there'll be 3 arbitrators, or something to that effect. I don't know what the exact terms of an AT&T contract are, but those are the kinds of terms that go into to arbitration clauses. Arbitration is really expensive, and particularly it's expensive if you go before those bureaucratic watchwinders, the American Arbitration Association, a group of serious bureaucrats. I have been an arbitrator for the AAA, the American Arbitration Association. There are clerks in the bowels of the AAA who just torture you with paperwork. It costs, when I last looked, about $1,750 just to file a case before the American Arbitration Association. And it's more money if it's a really big case. But it's a very expensive filing fee because these people get paid by the filing fees. If you want to file a case in West Virginia Circuit Court, when I last looked, it was $135. Has it gone up?
It's gone up a bit, yeah.
What, 140?
There's always a new fee for something.
For something, right. But basically, it's not very much. The federal system rapes you. I mean, I think it's, $300 or $400 to file in the federal system. Again, I'll tell the audience that we have clerks in our offices who go and file cases. We don't actually do them ourselves. But the cost of using the courts is much lower. Arbitration is really expensive and it's really complicated. The other thing about arbitration is that the very clause that sets up the arbitration usually limits your damages so that it is more difficult to get the company to settle with you. You see, they have you by the short hairs in that there are no other kinds of causes of action related to your underlying dispute, like for humiliation or for failure of good faith, all kinds of other things that you can do in the court system.
They'll give you the cost of the cell phone back,
right,
or something like that. We're talking about arbitration. My guest is attorney and former West Virginia Supreme Court Chief Justice Richard Neely. I'm Dan Ringer, and this is The Law Works. We probably ought to explain a little bit about what the process of arbitration is as opposed to the process of using the civil courts.
All right. In the civil courts, you file something called a complaint, or your lawyer files a complaint. The other side has 30 days to answer. They answer the complaint. And now you get something called a scheduling order. And the scheduling order tells you to do certain things, to take depositions of witnesses, to make certain disclosures, to provide expert reports to the other side, different things that are all part of the process of getting ready for a trial. And if you've got a decent lawyer who's fairly aggressive, in about a year after you filed this complaint, you get to go to a jury trial. Or at least you get to have the judge listen to respective motions for summary judgment and decide whether there is or isn't an issue to go to the jury. In arbitration, you file this petition for arbitration. You have to figure out where you're going to file it. I mean, you either file it to the American Arbitration Association. Sometimes if it's a securities case, you file it in front of the Financial Industry Regulatory Authority, something called FINRA. Or you can file it in any one of a number of other forums. Or in fact, and we'll get to this, you can actually have an arbitration clause that allows you to do what's called a non-administered arbitration, where your lawyer and the other guy's lawyer just pick an arbitrator and you go to arbitration without any further ado. That's by far the best system. But that's not the system that's imposed in most contracts, because the object is to make it so complicated that the consumer gets screwed.
One of the complaints that I have heard about the arbitration process is that these big businesses are a source of revenue for the arbitrators that the arbitrators depend on, and they may want to please them.
Herein is a story. We actually put the National Arbitration Forum out of business. I once was sitting fat, dumb, and happy in my office and received a letter from an organization in Minnesota called the National Arbitration Forum. They said, would you like to be an arbitrator? Well, I have been an arbitrator. So I filled out the questionnaire, etc., sending it back, thinking that they were looking for retired judges, because many commercial arbitration clauses provide that the arbitrator must be either a retired or former state or federal judge. So I send it back, expecting to be invited to do fairly serious commercial cases. And they sent me 3 credit card cases. 3 cases by a credit card company against consumers. And the consumer had not even bothered to answer the complaint. So what they expected me to do was to enter judgment without any further ado. And they had provided a judgment form that gave the credit card company all kinds of fees that they would never have gotten in a state court. They would never have gotten attorney's fees. They would never have gotten a penalty fee. They would never have gotten about 3 or 4 things that I struck out of the form, out of the form that they sent me. And it became obvious to me that what they were doing was becoming a collection agency, just like the old Justice of the Peace system, which the audience out there, unfortunately, are too young to have remembered. But we always used to say that the term JP stood for judgment for the plaintiff, because whoever was paying the JP, the filing fee, was going to win.
Well, we need to talk about that just a bit. Under the old Justice of the Peace system, the Justice of the Peace's compensation was part of the judgment.
Right.
And if he didn't enter a judgment against the defendant, he didn't get paid.
And that's what this was. Well, I noticed that this was just a screw job, and I wrote a law review article about it that appeared in the West Virginia Bar magazine, and strangely enough got republished in a whole bunch of other bar magazines. It had one of my usual temperate titles, and I think it was called Arbitration and the Godless Bloodsuckers, I think was the title of the piece. But it got...
Richard is a legend among lawyers for saying what he means.
Well, this got national attention. At the same time that I did it, there was a lady law professor at Harvard who had the same experience. And she wrote an article in a much more elegant form than the West Virginia Bar Rag, and I can't remember what it was.
Which is the magazine of the West Virginia State Bar.
State Bar, right. And then the wife of the governor of Minnesota had been employed by the National Arbitration Forum, and when she saw what they were doing, she resigned. So the Attorney General of Minnesota decided to bring an action against the Arbitration Forum on the grounds that it was a screw job for consumers. And they called me, because I'm a former Chief Justice, to come out to help file the complaint and explain to the public what was going on. So I flew out to Minnesota. We had a big press conference. We filed a 93-page complaint. And 5 days later, the National Arbitration Forum went out of business. Now, that's an example of how arbitration has been abused. I am sure that there are other arbitration operations that are operating exactly the same way. They are truly oppressive. So, what should we tell in the limited time we have? What should we tell people out there that will help them with arbitration? One, try not to enter into an arbitration agreement. You will probably not be able to avoid it much, because all the cell phone companies, all the credit card companies, all the stockbrokers, everybody...
All the car leasing companies.
All the car leasing, everybody has an arbitration clause. There isn't much you can do about it, except that when you have a dispute, don't be afraid to tell the company you want to go to arbitration. And the way you do that is you can go into the website of the West Virginia Secretary of State, and there it will give you a link to business organization data. Put in Hertz rental car, or put in AT&T wireless, and up will come a listing of all of the officers of that corporation. Look for the general counsel and send the guy a letter which says, hey, I want to go to arbitration, and if I don't hear from you in 30 days, I will deem the arbitration to have been waived. Now, that will get their attention. At that point, you might actually get them to do something reasonable with you. It has always worked for me on behalf of these kids who are into it with the cell phone companies, et cetera. If indeed you feel that you want an arbitration clause, for God's sake, don't ever put in the American Arbitration Association. They will absolutely wear you out. There is something called the Rules for Non-Administered Arbitration, and they are promulgated by the International Institute for Conflict Prevention and Resolution, CPR, just like what you do on the guy's heart. If you put into Google non-administered arbitration, up will come the rules. And you simply put into your contract that all disputes shall be decided by an arbitrator appointed pursuant to the rules of the International Institute for Conflict Prevention and Resolution. And then if you have a conflict, you get your lawyer to contact the other side and get the other side's lawyer, and the two lawyers will always be able to agree on a third neutral arbitrator. I've not seen any instances where two lawyers can't get together and figure out some guy who's going to be fair and has not related to either one of the sides. Short of that, you can, under the rules, under the CPR rules, you can go to the chief judge of your circuit court and ask him to name an arbitrator, if there really isn't any agreement. But don't get one of these administered arbitrations because they're fabulously expensive. You're paying for oodles of bureaucrats. If you do it under the CPR, you're only paying your lawyer, the other guy is paying his lawyer, and then you get the guy in the middle. You know, I mean, you get some guy who looks like me if you come, you know, or you get some guy who looks like you. You know, and we generally don't charge full freight for serving as an arbitrator. And so it's much, much cheaper.
Arbitration is in that area of law called alternate conflict resolution or alternative conflict resolution. The other branch of that is mediation. How do arbitration and mediation compare?
Oh, there's no comparison. They're entirely different animals. I mean, it's like horses and cows. Mediation is something that's become fashionable in the hopes that two sides can compromise on a case. It's particularly used in major tort cases. I mean, I do it all the time.
Tort cases, personal injury, property damage,
right,
that sort of
personal injury cases. But it used to be that the lawyers did it. You know, the bringing in of the mediator is just another opportunity for bureaucrats to make money, right? I mean, it's like continuing legal education. There are hundreds of coffee-sucking bureaucrats of one kind or another in law firms and think tanks, et cetera, who are going to make money on mandatory continuing legal education when, as a matter of fact, it's utterly useless because the programs are fabulously boring, and the people who are serious lawyers are going to go out there and read stuff anyway, and the people who are fools aren't going to pay any attention to the mandatory legal education. So there's
the opinions of former Chief Justice Richard Neely are solely his own, not those of West Virginia Public Broadcasting.
Right.
Law Works.
Well, but it's true. You have hundreds of bureaucrats out there who are looking for things to do.
But the difference between arbitration and mediation is the arbitrator or panel of arbitrators decide the case.
Decide the case.
In mediation, the mediator just tries to help you find a resolution.
Yeah, if he's any good. Most of the time, he just carries messages back and forth. But Herschel Rose and I used to do in the First National Bank building in Fairmont, West Virginia, by calling down and saying, Herschel, you want to settle this case? Yeah, I'm going to give you $15,000. No, you're not. You're going to give me $35,000 on your best day, right? About 10 minutes of that, and we had it settled. We didn't need a mediator, right? But lawyers, what happens is supply creates its own demand. When I ran for the Supreme Court, there were 1,765 lawyers in West Virginia. Now there are 6,879, because I asked the bar the other day in anticipation of this program. So that you have this huge number of lawyers, you have to find something for them to do. So the existence of lawyers has multiplied paperwork, multiplied bureaucracy. Now instead of having two guys get together for 10 minutes to settle a case, you've got 3 guys getting together for an entire day.
Okay. Before we quit, I want to ask you one last question, and it has nothing to do with arbitration. Right. Richard, we've been involved in wars for the last 10 years or so, and you're wearing a lapel pin. What is it?
Oh, it's a Bronze Star from Vietnam.
Richard Neely, thank you for joining us.
Oh, thanks.
Thank you also for joining us. On behalf of the LawWorks, I'm Dan Ringer. Good evening.
If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes.
The LawWorks is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the LawWorks is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.